So committee, we're back at it and we're gonna be talking about H614. It's a timber trespass bill. And I think, Michael, you did some work on that for us.
Yes.
And we got a copy of Michael's work. And thank you, Michael, for being with us.
You're welcome. Do you just want me to review the amendment?
Yeah, please.
So there was concern that I think you heard, either in testimony or from advocates outside of the committee about certain aspects of the bill applying retroactively. Specifically, requiring financial surety if a person has committed two or more offenses that led to civil judgments and the person has not paid for their damages. And then similarly, there is a section of the House passed bill that would provide that as a condition of future operations as a harvester or engaged in timber harvesting, if you had two or more criminal violations of timber trespass or home or land improvement fraud, or two or more civil judgments that were unpaid, that you were prohibited from operating in future unless you posted the financial surety requirements. Now, there's concern that that is retroactive in effect and would raise constitutional issues related to what's called bill of attainder or ex post facto. Ex post facto is when you criminalize a behavior after it has occurred and then punish that person for the behavior. Bill of attainder is similar. It's really the civil version of ex post facto, when a legislature working without the input of a judge penalizes an individual or small identifiable group of persons, and there is a penalty. It is not a damage or a reparation or something where the person is basically compensating for their actions. It's strictly a penalty, and it applies retroactively. That's bill of attainder. And I don't necessarily think bill of attainder is applicable here because I don't think this is a punishment. I think this is a condition on operation. But there is definitely an argument that would be made or could be made that it is constitutionally suspect because it's retroactive application.
Even if you had prior convictions?
So the way to do that is to be very clear that every time you're referencing prior judgments or prior convictions, that the bill is prospective in effect. And that's what the amendment does.
So it does that.
Right. It in the first instance of amendment, in that those provisions related to timber theft, where it said that a person had to provide financial surety, that there was language that said, let me just find the language, where it said the person is subject, if the person is subject to two or more civil judgments and has not paid all the required damages or restitution, then they would be subject to the financial surety requirements. I think there's concern that law enforcement would have to figure out these prior, they would have to go and look for prior violations and then determine whether or not the damages have been paid or not for those violations in the past. And I think law enforcement does not want to do that, and would find it a bit difficult to do. So the first aspect of the amendment would be to remove that requirement that they have not paid all required damages or restitution. What a subsequent part of the amendment would do on page 2 It would say the financial surety requirements established by 13 USA 3605 shall apply prospectively and shall not apply to convictions or civil judgments that occurred prior to the effective date of this act. So the effective date is July 1, 2024. So if you get 2 or more civil judgments, regardless of whether or not you paid or not, you're subject to the financial surety requirements. But
That's
in the
moving
future,
forward.
yes.
Good.
If you get 2 or more criminal violations of timber trespass or land improvement fraud or a combination, you're subject to the financial surety. It is not looking backward anymore. It is purely a prospective application. And that takes away, I believe, some of law enforcement's concerns about arguments being raised about retroactive application and constitutionality. And it does raise fairness issues for those persons who were subject to or who achieved or obtained civil judgments and persons have not paid, and those persons that violated against them are continuing to operate. But you have to balance that equity concern versus the concern raised by law enforcement of these constitutional arguments being raised against their enforcement. And so that's kind of a policy decision for you. Are you going to risk the litigation because of your equity concern?
Well, I mean, the testimony that we've heard, some of these people that violate the law have done it 3 or 4 times, or they do it every year. And I mean, it's, but if it's constitutionally questionable whether you can back up, and I mean, we don't want this thing to fail. I mean, you know, so it's an issue that, but it's a hard call because these people have already been burned. I mean, not that they'll ever get their money, anyways, but at least they're helping to protect maybe another person down the road. Is there a second offense? Is it a felony?
It depends on the damage that you created. Felonies and misdemeanors in Vermont are based on the monetary value of the harm. And so
Like $1,000.
so you can go to like the home improvement, land improvement fraud section on page 2 of your bill, where of the bill as it passed the House, where for instance, where is it? It's actually on page 4. The bill has passed the House. On line 11, if a person's convicted of a second or subsequent violation of a misdemeanor land improvement, home improvement fraud, they shall be in prison not more than 5 years or fined not more than $10,000. That's a felony. All right, so it depends on what you did, how many prior convictions that you had, what the damages and or the fines were. So some of these are going to be misdemeanors, some of these are going to be felonies, but it doesn't matter for the purposes of financial surety for timber trespass. If you have 2 or more convictions, then you have to get.
Sears was kind of leaning toward a second offense, felony offense. So then he said there's a lot more penalties that can be levied on an individual with a felony.
That is true. There are many more repercussions and or consequences for felony convictions in this state and otherwise. That is correct. So I think. So right now, home improvement fraud, existing statute. No change to it. It's not about whether or not. The penalty determinations is not necessarily about whether or not the violation was a felony or not. So for instance, a person who's convicted of a subsequent violation of subsection B of this section, which is where it's just a violation. That second throws you into 3 years or a fine of not more than $5,000. Again, that's a felony. So 2 misdemeanors throws you into a felony. But it doesn't say misdemeanor, it just says any 2 second or subsequent makes it a felony. So any second or subsequent for home improvement fraud, land improvement fraud, that's already gonna be a felony.
Second.
And so to mirror that, timber trespass is any second or subsequent gets you into the financial surety requirements, because that's what happens in land improvement fraud too. You're just mirroring second or subsequent moves you into the financial surety requirement. I will admit that the second or subsequent timber trespass, that might not be 2 felonies. That might be 2 misdemeanors. Because when you look at what the penalties are for timber trespass. So for first offense, imprisonment of not more than 1 year.
First offense.
First offense. So that's a misdemeanor. For a second or subsequent, imprisoned not more than 2 years, or fine not more than $50,000, or both. So when you have those fines and imprisonment, so imprisonment of not more than 2 years, that's a misdemeanor. 50,000 or more of a fine, that's a felony. But when you have those 2 competing, it's gonna default to a misdemeanor. So these are 2 misdemeanor penalties for timber trespass. You could amend that second or subsequent offense for timber trespass to move the imprisonment to not more than 5 years or not more than 3 years would be fine. And that gets you a felony. And then you would be mirroring land improvement fraud and that second or subsequent for financial surety in the very same way.
So it'd all be the same.
It'd be very, and you would take away Senator Sears' argument that it has to be for the.
Yeah. I think that would give the committee think that makes sense.
Okay.
Are there any other issues that we spoke about, Michael, that?
Well, there is, it's a very similar issue in the bill as passed the House. It was that requirement that if you previously had 2 or more convictions or 2 or more civil violations, that the AG was going to go and notify the court of that and your requirement to get financial surety. It's the same retroactive constitutional issue law enforcement has. They don't want to allow those arguments to be raised in any prosecution. So they're asking that that section from the bills passed the House be removed. And instead, what's inserted is that language about in all its perspective in application. So again, it's the same concern about the retroactive application and whether or not it raises arguments of bill of attainder and ex post facto. It definitely raises arguments. I don't think those arguments would be successful, but law enforcement would just prefer not to have those arguments raised because it will be an additional issue that they would have to address in any law enforcement issue.
I don't know, do you have a question?
Yeah, I think they're already short-staffed, is that the concern? They already have
It's-
so few officers to do anything and.
Yeah, and it's not just, you know, your troopers, your police on the ground, it's the state's attorneys and the attorney general. They would prefer a cleaner path of enforcement and taking away the sergeant.
So we had that, the way it's crafted.
The way that the
now,
amendment
because
is
we
crafted.
didn't put
Right.
that other stuff in.
Right. You took out the issues that were creating that.
Now, what happens if a person got convicted of these things and they aren't supposed to be able to cut wood without a box, right?
Or if they're working for somebody else. Right, so
Or they could go run a chainsaw.
they could go work for another company as long as the company is effectively a bona fide company, that it's not, you know, you haven't shifted corporate ownership to your 12-year-old,
Yeah.
right? Things like that.
I mean, people get stopped constantly for speeding. And they get tickets and like, well, they usually go back to speeding 20 minutes after they got their ticket. And they're done. I mean, what's gonna stop? Because these people don't have a bond. Who's gonna stop them?
Well, under land improvement fraud, your failure to post the bond is a crime itself.
Yeah.
Now, that's-
Post it with force and cards, or who would they post?
They post with the attorney general. It could be clearer for timber trespass, whether or not that failure to post the bond is a crime in itself.
So I think we ought to have it as clear and precise as, yeah.
I can do that. I can say failure to post the bond, and I'll just mirror what it is for land improvement fraud. It's a imprisonment of not more than 2 years and a fine of not more than 1,000 for your first. That okay?
Now, should there be anything in the bill that a lot of people that have their forest property and forest management plans, I'm wondering if the guy comes, the Air Forester comes, and you're in there right then cutting, or that you just cut. And I don't think though, people would let them come and cut without. Cause you have to notify people if you're in current use, you have to, notify that you're getting timber cut through your forester. Something about the forester being able to view the bond, the surety, who's gonna check that? If it's not my forester, and I mean.
Yeah.
The forest people, there's a county forester. Should they have to report their bond to the county forester or something like that? Who knows they even have a bond, or they don't have a bond?
The court could do that. The court.
The attorney general, somebody's got to be able to check that bond out and make sure that it's up to date.
Is it like a permit, like you carry with you? How, Jared's point, I show up to work and the guy says, where's your proof that you got a bond? You carry it like a person? Right.
So, you don't, it doesn't require you to carry it on your person, but you would have opportunity to provide that record if you didn't have it on your person. But right now, land improvement, the person has to notify the attorney general of their intent to engage in their filing of the surety bond. Right, so whenever a person is convicted of home improvement or land improvement fraud, person notifies the AG, the court notifies the office of the attorney general. The office of the attorney general shall place the person's name on the home improvement and land improvement fraud registry.
And so it's on the registry
It's on the registry.
that you can pull up on there.
Yeah, you could. If you, and so a person convicted of timber or trespass is also added to the registry. But you could add the requirement that they notify the county forester in the county where the violation occurred.
I mean, I know at home, our county foresters sort of know everybody and, you know, what was happening up there. And there is one, I believe, in every county.
So the issue with that being for land improvement fraud is land improvement is going to be a broader, land improvement fraud is going to be a broader crime than just harvesting timber. It could be failure to do site work correctly, failure to do grading correctly. The county forester might be getting notice of crimes that are unrelated to.
See, we only want to enforce.
Ed Larson from our Forest Products Association. I see what you're asking for. I think that's a good idea, that there's be some kind of a check and balance there. When they have to, you know, on the second offense, they have to notify the AG they're going to engage in another activity. And then they have to get a surety bond. Okay? So the AG knows they're going to do that. Couldn't they put it on the registry that they did indeed obtain a bond? Like another field on that, so that any law enforcement person could see the activity, see the logger, he could look up the registry and see, yes, they're on the registry and yes, they have a bond.
Yeah, they could provide proof of filing the surety. Letter of credit, and then the AG would be able to say that on the registry.
See, there's gotta be a way to check that, or
What's the point?
these guys are just gonna run wild and we aren't gonna be any better off. We're gonna do it, they ought to do it, so we can at least slow them down.
I can do that if you would like me to do that.
Well, that is, I think.
You can look it up and chase down a county forester. You heard about this guy? Did you get a bond or what? Just look it up online.
Yeah, you do it right online and I mean, yourself for most parts and if your forester would, if they'll know about this, so then they would call the county forester if they went and checked Mrs. Jones's property and half the trees were cut. As Joe Wall from Lindenville got a bond. And so we'll set it up so the AG would send a list to their county, but it won't be much of a list. Because there's not that many, because we'll send the names of these individuals to their county forest. Or
Okay. Are there companies in Vermont that write the bonds?
Yes.
Make them send it to the Attorney General.
Responsibility of the violator to do all that, subject to,
Sure.
they could ask their insurance guy to send it for them. That probably would provide that service.
So those are the changes. I'm just trying to think whether or not at this point you want to strike all or
well, it'd probably be easier when,
I think it's gonna be easier to explain. Especially if I highlight the changes.
yeah.
Okay. I agree with that.
Any other, Irene?
Thank you, Mr. Chair. So, we heard testimony that the House had talked about a seizure amendment.
Yeah.
But it didn't go anywhere, and I just want to pursue that with you in case seizing any of these assets would be a way to stop this sooner than later.
So seizure was in the bill as it was reported out by the House Agriculture Resiliency and Forestry Committee and went to judiciary and it House Judiciary and it had significant debate in judiciary about really only seizure, forfeiture and seizure and forfeiture, and whether or not it was administratively doable because of the nature of some of this equipment, how to get a flatbed out to seize a skidder, etc. The other administrative aspect of it was the equipment even owned by the person committing the violation. Now there is an aspect of existing seizure and forfeiture law that allows the actual owner to come forward and say, I'm the actual owner and I had no knowledge that this was being used for criminal violation. But that's an additional kind of complicating factor to seizure. And then there was the cost of seizure. Where do you put this equipment? How is it stored? Because there's a fiduciary responsibility of the law enforcement agency that seizes it to maintain it so that it is effectively usable again in the future. And where would you put a skidder? Where would you to maintain it? And then the House Judiciary Committee had, and it was a big part of the discussion. They had concerns about how the proceeds from the forfeiture proceeding of the seized equipment are used. Currently, they're largely used just for law enforcement and allocated between attorney general, state's attorneys, and other law enforcement. And then the rest goes to the general fund. And the House Judiciary Committee had concerns about how the victims of these crimes would not be getting any compensation from the forfeiture sales. And they thought that was inequitable. And then they started rewriting the allocations of seizure provisions. And it kind of started to cascade it was just about forfeiture in general at that point, and not just this bill and these forfeiture proceedings. And at that point, I think they were just like, you know what, this is too much and too complicated for this bill. We're just gonna take seizure out, especially since law enforcement was saying they would have a difficult time actually doing it.
So there's no such thing as selective seizure where you take the guy's pickup because that's how he's going from house to house to sell his.
So you,
Service.
law enforcement still has some seizure authority under general seizure for violations and crime. It's not as specific and clear, but they still can seize. So it's still a possibility, but it's not that kind of clear consequence of a violation as it was when it came out of house agriculture. And you know, it's a. I don't want to say it's a theoretical issue versus a practical argument. I really do think if it was ever used the first time, it would kind of send like a chill through the industry, that especially if the person that was committing the violation actually owned the equipment. But that I think is really where the boots are on, that issue is really tested. I don't know if they either own the equipment fully, probably subject to a lien. And so the bank would have to assert their lien, and that bank would get all of the forfeiture proceedings first. And then if they do own it outright, it's probably not worth as much as
That's the
you
difference.
think it is. And so,
Yeah, back to the pickup truck the guy drives to sell his service before he brings his heavy equipment in. Is it logistically a nightmare because he has to
So-
wait for 3 years for a trial because our courts are so back? Like, I'm just trying to figure out, at what
so,
point, when you seize that pickup, can you actually sell it for money? Is it gonna be so far down the road that the truck won't work anymore? Cause no one's using it.
I mean, that's part of it too. You gotta maintain the truck, right? In working order.
Well, but can you even seize it if he hasn't been convicted yet?
Yes.
Okay.
Yes, you can.
I don't know if Bill Seer clearly did
Right,
this, okay.
and but that was an issue that came up too in House Judiciary, just the equity of seizure. And there's a provision in law that says that courts. So, and one witness was arguing that this provision is a prohibition against seizure, but I don't agree. There's a provision that says that courts can't, as a damage or as a consequence, as a fine, seize the implements of a person's trade, right? Because then they would have no way effectively to pay off any violations. I think this is slightly different. Seizure is to prevent the use of equipment that was engaged in a crime again, not to take as a penalty the implements of a person's crime. But that created some anxiety as well. They're like, well, maybe you could still argue that, and maybe we don't want to do that here. Again, back to the whole kind of. They were just not comfortable.
Okay.
They were not comfortable with it, and I think you probably have a very similar discussion in your.
Okay,
Wow.
well, thanks for summarizing all that, so.
These 3/4 ton pickups that these guys use because they got fuel tank in the back and chainsaw. You know, they're between 75 for a cheap one and 100. So they don't own those either. You know, they got mortgages and payments on those, so even if you took it, you wouldn't, I mean, you could have the finance, maybe have to pay it off or pay their claim off to get the pickup. But I've seen some of the pickups and I wouldn't want one sit in my yard. I don't, they're usually beat up, muddy and, you know.
Yeah, but a Platinum 350 costs like $75,000.
Oh, yeah. I mean, they aren't cheap.
Right.
Okay,
Anything else for the timber trespass that anybody can think of that we're
no, I think we're making progress.
missing? And did you bring anything on the miscellaneous bill?
Did you want to?
I did, and this was the conversation
Well-
apparently.
This? is-
Oh, yeah,
How much time have you got on it?
I hear it's new.
So you got comment you wanna make on the trespass bill?
I'd rather hear what else he's gonna add in addition to then come in after.
I just, want me to summarize what I'm gonna add in the trespass bill? I am going to, clarify that, a second or subsequent violation of timber trespass law is a felony. And that will continue to be subject to the surety requirement. But that would address Senator Sears, the chair of Senate Judiciary's concern that the surety should only be there for a felony. So that would address that. The other thing I was going to do is that the failure to post a bond for timber trespass is a crime itself. And I would mirror the criminal penalties for land improvement failure to post a bond.
There's something in the database, right? You're gonna have somebody that information in the database
Oh,
about this.
right, as part of the requirement to post your surety bond, you will have to show proof of that. And then, part of the bill for land improvement and is when a person is convicted, when they're being added to the registry, they're gonna be added, shall place the person's name on the home improvement and land improvement fraud registry, and whether the person has posted financial surety as required. So the registry will state whether you've been convicted, whether you posted your bond. That will allow a county forester to look at the registry and look at whether you posted your bond. And so those are the main changes, other than what's in the amendment that I already discussed.
You got it?
Pretty much,
When
really
might-
appreciate the detail he goes into.
When might we can send you a copy of the bill once we
That would
you
be
know, get
great.
it put together, or you're more than welcome to come and spend some time with us.
Probably both.
Linda has your,
I believe she does.
Have your email?
I think you do, yeah. I'm not positive.
so.
Could you go send me the-
Miscellaneous ag, we talked about adding,
So I apparently talked to, I think both an aggravated citizen and then to Ted Brady at the league about the issue of animals running at large.
Yeah.
And how that is an issue because it's not very clear what municipalities have as authority to regulate that. And also the statutes that are on the books for regulation or penalties for animals running at large are so old that the fines are like $2 or $5. So it's not a disincentive to anyone who allows their animals to run at large. And it's not an incentive for municipalities to enforce either, because it's gonna cost them more. Send somebody out to do the work to enforce, and then they get $2. So what the amendment will do first is to add to municipalities' general authority to adopt ordinances to allow them to adopt an ordinance for the regulation of animals running at large. I'm finding my amendment that we got to got lost in the shuffle.
And that, those suggestions came from, right,
Brady, temporary. Do you remember what the number was gonna be, Mike? It goes from $2 to what?
It depends on each violation.
Okay.
But do you?
no,
But here,
877.
I've got,
Okay.
so. If it, is it on the website?
Yeah.
Okay.
I got 877, you're talking?
Yep. And so if you scroll down, there will be an amendment added, section added to the bill that adds to municipal authority under 24 VSA 2291. So it's up further than it's up. It's right there. Yep. That allows the municipality to regulate by ordinance regarding the fencing of livestock or poultry. So first question, is it just for livestock or is it for poultry as well?
no, watch.
Just, all right, so that would be,
You expect chickens to be in the road, right?
right,
We're not gonna get a lot of our committee members voting against this, because his run lows.
so that
Talk to the town. too.
that would need to change, it would just be for livestock. And when they are found, or being on any public land or public way is effectively a highway. Or land belonging to a person other than the owner of the livestock. Without the landowner's permission, so it would, then they can have an ordinance that the municipality can enforce on their.
Okay.
And that would be up to municipal law enforcement to do that. And then you move to the amendment to the existing penalties for animals at large. If you move down to the next page, Linda, you'll see that the current one for cows and is $3. And that is moving to not more than 1,000 nor less than 50. So, I mean, it's
For each animal,
right, for each animal.
so if you had 5 out there, it'd be a 250. That's,
So that'll be a significant disincentive. The one thing I talked to Tucker, one of our government ops attorneys, about whether or not it should say by a law enforcement officer or the select board. And he thinks it should be law enforcement officer for municipal employee or municipal officer. So you could have, your public works person that has to collect one of these animals, potentially issue the citation instead of, because it says the select board, you think the select board's not gonna be out there.
no,
So he recommended a change from select board to municipal officer.
Or representative.
our law enforcement.
Or you could say municipal employee.
You think a representative of the select board?
Of the municipality.
Yeah.
I don't know. Yeah, I agree with this. If there's a 5-person select board, then I could be running around $50.
Right.
So if you change that to municipal officer, municipal employee, or whatever you want to do, you're gonna make that change throughout these sections,
Okay.
because it says select board.
Municipal officer or employee.
Yeah.
And so you'll see similar changes for when the animals, the cattle, horse, sheep, goats, swine are in a public park. It's being increased, not more than 25, which is not less than 5, to not more than 100, not less than 50. And when they're in the yard of a townhouse, church, or schoolhouse, it's again changed from not more than 10 to not more than 100, nor less than 3 to not or less than 50. Same within a burial ground. And then land or premises of another, which is probably the most common that you're gonna get enforcement of, 3345 going on to the next page. Good. And you'll say when it goes on to other person's premises. One of the questions I have is after the latter has given the owner notice, do you want them to require notice? So you only get to fine if the person whose property that the animals are on notifies the owner and the owner doesn't come and remedy that issue.
You mean first.
Right.
Well, I should think the owner of the property that they're on would have to call the neighbor when.
Yeah.
That would only be fair,
Like,
because you might, as a farmer, you might not know that the animal sale or animals. But so, yeah, there should be some type of notification, Michael. But, you know, we rolled by it pretty quick, in the previous section. A few years, now it's quite good because we put a whole new fence up, but the farmer near the cemetery,
right,
cows got in the cemetery.
Oh, really?
And I'll tell you, there was serious damage because the old grave, you know, that didn't have bolts. And they decayed and mostly already, you know, it was not good. And that, see, that line is
the same.
sick.
They're also liable for damages suffered.
Oh, they are damages
Yeah.
as well.
Yeah. But there has to be a civil action.
Damage liable for the damages suffered.
Yeah.
Okay, so
How would you notify someone that their cattle were in the cemetery? Who do you call?
Well, in most of these instances, they,
discipliners usually.
right, I mean, well, that's who would respond. And then you usually know who's
Owns the
livestock
cemetery?
they are.
Would you say state center?
No. Who owns the cemetery?
Is it called state center?
I didn't
Oh,
read
So one of the things that
What's yours number?
one of the things that the old language does, and it's not shown in the bill, is it allows the municipality, and in some instances, that neighboring landowner to impound the animal and to keep the animal until the owner pays for any of the damages that the animal did.
Yeah, your chickens, you're gonna start paying for their damage.
No, we
So-
include poultry.
You're gonna be over washing the neighbor's, wooden fence that they roofed.
If they go pooping on the step and it gets tracked in, you're
Right.
cleaning.
I want to let you know I have 5 geese arriving at the house today. Very excited.
But impoundment creates a lot of,
Oh, right.
conflict.
For sure.
And so just so you know that if somebody asks you, can the municipality impound? Yeah, they can. But they don't normally. What they largely do is that they require the owner to come
But
collect.
we're just updating the old monetary.
You're updating old monetary penalties, you're not changing the underlying law, but you're giving municipalities the ability to adopt their own ordinances.
Yeah.
For the control of animals, which could be more effective and administratively implementable.
Okay.
Well, I'll get that thrown in, bill form.
I do also need to say that this doesn't address issues about animals at large, all of the issues with animals at large. There can be civil cases,
Oh, yeah.
there can be criminal cases as well, as I think some of you know from a few years ago. And so this doesn't address any of that underlying authority for civil or criminal actions for animals at large as well. Just wanted to put that on the table.
Yeah, we're okay with that, I think.
Yeah.
And the other thing it doesn't do is doesn't do what other states do, is implement a statewide fence law. And that's how a lot of other states address these. But they have literal agencies that are in charge of going out and making sure your fences meet the standards. It's like, they're called fence riders.
Brian could, you could be an inspector.
It's not a bad idea, actually.
A fence viewer?
That's your.
Well, no.
What do we
you
do
know
when we
all
get
about
that no
fence.
fence stuff going?
Would it be a secretary level position?
Yeah. No offense.
So if you take this bill to the floor with these provisions, I assume somebody's gonna ask you, well, how do you prevent this from happening? You really need a fence law, and if you need to have a fence law, you need.
Oh, excuse me, you can put up any kind of fence you want,
It could be that.
and animals can get through it.
If they
And if
see-
your dog next door comes and chases my cows and they get through a fence that I just spent $65,000 on,
You can shoot the dog.
Better not be Archie. Archie's always out.
Or Ben?
Benny.
Well, I'm talking about mine.
Oh.
I don't want Benny to get hurt either. I'm talking about Archie.
Benny doesn't go out unless somebody's with him.
Yeah, Archie generally doesn't go out,
Benny
but there
has-
should be a Benny Archie
Not
exception
old
in
enough
this.
for that.
well, keep Archie
Right now,
home, from
He's always
chasing my
He's
cows.
always out.
Right down
No
the
bigger.
road.
Ooh, Beagle?
Oh, it's a beagle, my gosh, my cows.
He wasn't oh.
But the ushers, cows used to end up on my property. Remember the ushers? Ushers on Bory Hill Road.
So, Myrie,
So I have a question, if we're gonna insert all this language about animals escaping and things, should we have in some folks who have animals that do escape to see how they feel about this, to make sure we're not. Our penalty isn't too high, or we didn't leave something out?
Who?
People whose
Oh.
animals escape, you know, like the average farmer in Fairfax who's got cows that might escape. I don't know, should we hear from them rather than just craft this sort of in a vacuum?
I was just telling, the ushers, when I lived on Bory Hill Road in Crosby, they would get out sometimes. I just don't want, and it was totally by mistake,
Right.
accident.
the only
Clever.
time this would kick in, I would expect from a habitual offender.
Right.
Somebody that, like we heard, that their cows are out twice a week, 3 times a week. The average farmer, I mean, you got $2,000 in value in an animal. You don't want them out in the road.
No, but they do escape, so I just wanna make sure that we're grounding this bill in reality of who escapes and when, and does the bill say anything about habitual offenders, or is it just the random cow that gets out and then full neighbor says, that's it? You need to be fined or something, because farmers are already on the financial edge.
It doesn't specifically reference if you're habitual or not. It allows the enforcement discretion. Every penalty law has enforcement discretion. The law enforcement officer, this municipal officer will have discretion to bring the charge, the citation or not. Case by case basis. So that's not written into the language, that's just implied as part of their underlying authority. And then the ordinances that the municipalities will adopt, they could be about habituality, or it could be about changing the penalty based on subsequent offenses. You're not limiting that. As to whether or not it's an issue, it's been an issue for a long time. And it's not just cows or horses. There was the great pig escape of cows.
Oh, yeah.
And that went on for a while. And the Department of Fish and Wildlife got so anxious about it because they were concerned that the pigs were gonna go run wild. That they came in and requested language that they could go kill the pigs
Sure.
after a couple of days when they were free. So. I mean, and that was a long time, that was like 2015.
Yep.
And,
Is it that long ago?
yeah. So these issues have been around for a long time.
Right.
Well, and with the cattle and chickens, I bet it's been 40 years since those are updated or more. The farms,
So that'd be like
I mean, they're
$2.
back in the 30s, 30s.
Well, when you look at these laws. Let me just find one that is being amended. They don't have what's called legislative history. Meaning that they were this way when the laws were moved into the green books. When the green books were created. This is when those laws,
What year was that?
1954.
And they were already created prior to that.
And then another major update of these was in 1981. So those are like the timeframes you're talking about, these laws are coming from. They're either predating the creation of the green books in 54, or they were addressed in the 1981 comprehensive rewrite. So that's how old these laws are.
Where were the laws kept before the green books?
And what we call the white books now. You just needed to know what the public act was, and you had to go, they weren't compiled into the statutes the way that they are now.
There was a lot less.
Yes, the one watching.
Yeah, I mean. I could show you some white books from like the early 30s that are pretty wide.
But how long have you been here?
2004.
Uh,
2004.
So, but when I first came,
Back in the Stone Age.
there was Bill Russell and,
5 others.
yeah, at the most.
Wow.
And then we hired Smith on to do the dairy compact, but I mean, we didn't have many people.
Janet Ansel worked in the council.
Oh, wow. Before she was in the house?
Yeah,
She worked out, she was an attorney.
and she was counsel before the Dean administration.
Mhm.
And then went to the Dean administration. I think she served several roles.
Yeah.
Yeah. Yeah, well, that hallway where you are. That's all it was. And, like 4 or 5 offices. So there wasn't a lot of people writing for us. Larry,
Thank you, Mr. Mayor. Sorry to bring back the bill here. You mentioned somebody else helped draft this. Did I hear somebody, did I hear any?
Ted Brady from
Ted,
the
okay,
league,
from the league.
he,
All right.
he apparently talked to the chair
well,
about.
he sent us a letter from his testimony.
Right.
Yeah, he has some testimony.
Basically, what
Okay,
I asked.
I'm trying to reconcile that with the fact that I talked to some attorneys a while ago, like months and months. And they were saying this is a judiciary issue that we shouldn't be touching. So do you have any knowledge of that fact? This is not our. Like,
I think the judiciary sent it to us.
When I talked to
You
them,
mean it's a judiciary committee issue?
something like that.
Well, any,
And that we wouldn't be able to touch it or we shouldn't touch it or whatever. I don't know, maybe they were wrong. But that they come up before, like this person who's been talking to all of us recently, for months, and has had this issue, has brought the issue before to people, and it was in judiciary and was told this can't happen, but that doesn't reside in him. But again, maybe that I don't have.
So
Career.
I mean, these are all fines, that's one thing, which
Okay.
makes them criminal.
Okay,
So. But they are of the nature of crime that. I think is acceptable in the whole way that the judiciary committees and the judiciary as a whole is looking at setting penalties for. For a while, the penalties were just so out of proportion in some laws, for example. Interfering with the milk inspector could subject you to the same penalty as homicide. Whereas involuntary homicide with the vehicle is generally not more than, I think, like 8 years. So you could interfere with a milk inspector and go to prison for like almost life.
She wants to meet you.
But you could actually kill someone and only go to, so that they have been trying to rework those as to whether or not.
so just the fines are fine, it sounds like you're okay with that being in this bill, maybe it was like more of a broad thing that this president was requesting that we can't do or couldn't do. But okay, so as long as we've got fines in here and it's fine for us to do this, will it go to judiciary to check, or they don't need to see this?
No, they won't.
They will, they're fine, okay, on us,
The
where
one
my
the
memory
one
was
that
on reality.
really should be there, but they don't want it,
Okay.
is the other thing.
Okay, thanks.
And I'm gonna make sure that once, if we vote that out, once that reporter reports it, Beards is gonna stand up behind them
Okay,
and say, we've reviewed this.
Yeah.
that's important,
Yeah, well,
these are questions.
that, you know, that certainly isn't our jurisdiction.
All right, thank you.
Um. So. Did you have a question?
Yeah, I wanted to speak when everything was done. I think you misinterpreted what was happening when I gave him some praise for what he did. She mentioned the fact that she would send me what the bill was gonna look like.
Excellent.
I just wanted to say a couple words, and I think you're done at 12 or something.
Yeah,
So I just wanted to get that out before.
anything that Michael should.
No, and you can't praise him enough for what he does.
Okay, do you mind if I go?
No, go ahead.
Okay,
No,
great,
go ahead,
thanks.
Michael?
Lucy. Did Linda talk to you about the body?
Yep.
Thank you.
Well, I'll tell you, it's some interesting coming here. My name's Mike here.
Oh, right,
Victor.
you were in, right?
Yes.
Yeah, that's right,
Yeah.
good to see you.
And it's some interesting seeing how laws are made and how they're mediated and how everything goes. When I started out on this and was only working with Forest Parks and Recreation, I wrote a proposal that was 9 pages long. It nailed every nefarious logger. There was no escape from anything that could possibly be done. And when I came in here with Mark Mahaly, he took what I had and he condensed it down to what he called the bare facts, what he thought would go through legislation. And a lot of that was starting out with the fact of performance bonds, such as your people have suggested. And then we had the issue on trip tickets, and we had the things on seizure and forfeiture. And you know, we talked about going back into the past and getting people for previous things, everything. And I had, it was like I say, 11 pages, and I even found the financing for everything. So that, you know, because it was brought up a lot of time that they didn't have the money for things. If I found the money, I think I testified in that. The only thing I'm concerned with today, after hearing everything was stated and looking at the performance of the bill itself, it's been condensed down to the barest possible minimum, as far as I'm concerned. The performance bonding, as you're saying, only goes ahead. we're not even addressing what's happened.
That's okay.
That was,
That's,
we're not even addressing all the victims that have been injured. And we're moving forward, and I liked what you said today about Senator Sears. If you could get it to him, he could accept it as criminal and go forward with that. That would be more than what you have right now, because right now you're saying we're gonna impose fines. You have to pay the other fines, but don't you think you're gonna pay them now? So you can impose all the fines you want, you know, you say, well, they'll keep on working or whatnot. Yeah, chances are they will. And that's the only way you can get them to go forward, from what you're saying, although.
Well, that's what our lawyer said, that you get into a court.
Oh, I heard it's not constitutionally right. Yeah, I understand that. I understand that. I've learned a lot, believe me. And the only thing that I can say after seeing everything that's come down is there's gotta be some consequences for what they've done. We can't whitewash this, keep knocking it down and saying, you know, well, they won't vote for prison time because, you know, the legislators just won't do that. Then you're saying we won't do seizure and forfeiture. When are you gonna do that? And, you know, and it's just diminishing, and I'm expecting one of you to say sometime, well, you know, we did our best. You know, but they're gonna continue, so, you know, there was nothing, you know, 5.5 years for nothing. Because nothing that was actually consequential has happened. And there's a lot of people that were severely injured. Because between the damage and the forfeiture, not forfeiture, but the loss of property. So my thing is today, after hearing everything diminishing to almost nothing, and then hearing you say that Senator Sears said he would go along with jail time, which you said yourself, sir, that seems to be the only thing that we can take from them. Then we really want to take it from them. If that, I mean, you take that one lady, it was 240,000.
Yeah.
I mean, most of us, you know, if we went to court, it was 2,000 to 7,000 to 14,000, it was smaller amounts, you know, and. You know, if they don't add up like they should, you know, they would add up to 50, 60,000. I'm just, you know, so I guess what I'm saying is, Linda, I believe it was. Yeah. Is gonna mail me your proposals on the new bill, and then I can come in on the date that you're talking about it too. I just want some sincere, forceful legislation passed that is not gonna be pushed aside and we're gonna walk away there. I wanna see something that actually comes out of this after going through all these committees and all these studies and all this work that seems to be an imposition onto the state's attorney or the attorney general's office. And, you know, if you look at that, like the state's attorney says, the attorney general only has 250 cases. I mean, the attorney general and the state's attorney has 2,500. So, you know, I understand, but it's a case of priorities. Something that's been going on for over 40 years deserves some priority.
Well, you think it would, but nobody's acted on. See, the ag committee, we don't do forestry stuff. On the health side, they do forestry, but over here it goes to natural resources. If you took this same bill that came out of there and went down natural resources,
It's Chris Gray.
you'd be going home with nothing.
Well, believe, don't even remotely think that I'm not appreciative for everything. Every committee that I've gone to so far has been sincerely interested in what I've had to say and others have had to say. And you've worked towards getting something. I'm just saying, don't let your good work and my good work go to waste. Let's get something out of this, some way, shape, measure, or form that gives them accountability. That's all I ask.
I think this bill will.
See, I like to do things that are simple and straight to the point.
Yeah, they won't allow you to lynch them anymore.
Well, this bill's stripped down like it is, pretty well to the point. You know, you can go cut once, the second time you really get mad. Got some pretty good, legal stuff in there that they can hit them with the surety bond. I don't know how much those cost. I've never had to be bonded, but I would expect quite a bit. They could get a felony on the second offense, that's jail time. I mean, I think if you make it too convoluted, the state's attorney gets that, they don't even bring the case, you know, oh, this is too much. We're pretty damn straightforward the way we got it. I would think.
I certainly hope so.
Yeah. Well, I hope so too, because it needed addressing a long time ago. And for some reason, we happened to get it this trip around. And so we'll let you know when we're gonna get Michael back. You know, what his schedule is to get this done back. If it isn't Friday, hopefully it'll be early next week,
So potentially Friday?
or possibly next Tuesday. Cause, you know, we're running out of days.
Yeah, I got a big meeting I gotta go to Friday.
Yeah,
I got one today I was supposed to go to, but I came here instead.
that was probably a mistake.
I'm hoping not.
Well, we can push this off till Tuesday.
Yeah, that would be great.
I mean, if this would help accommodate your schedule.
I mean, who am I, right?
Well, no, you're.
Citizen.
You're pushing this,
Yeah.
probably wouldn't have got this far.
No, in our book, everybody's important. We put our shoes on just like you do, one in the dummy. I'll try jumping.
Champion.
No,